All right, good morning, everybody. Today we are going over the title and escrow from contract to close. I have Heather Jackson, our escrow expert here with Secure Title, and we're going to be going over everything really you need to know from start to finish, like what to expect from when do I need to start the contracts, when do I start communicating with the escrow officer, and how they can aid you in making sure you have a smooth transaction. So there's going to be a lot of information, so make sure you take notes. So with that, Heather, welcome to our little training today. And that's us. Hey, look, we're color coordinated again. We did it on the slides, and we're both wearing red, and our colors match. So, all right. So here's a brief overview of everything we're going to be going over today. It's as long as SpongeBob's list, and so buckle up. So go ahead, Heather, let's start with that. Let's go give some breakdown on the terms that people should be associated with and understanding.
So thanks for having me, Josh. And the terms that we apply in title and escrow, sometimes you'll find the terms are the same as what you've learned in school and what you as realtors talk about. But sometimes we actually speak a different language. So let's go through these terms a little bit. So an abstract of title is just a summary of the public record, what's on the title. A change of title specifically talks about the history of ownership of the property. Clear title is what we're always striving for when we're doing a transaction. We want to be able to give clear title to that new buyer. And so we always want to make sure that there's nothing against that property. And here's one of those fun terms, closing. So closing to me means when we sit down at the table and we go over all the documents and sign everything. Josh, what does closing mean to you?
So it meant lots of different things. I remember when I was first an agent, I was like, closing means that's end all be all, that's it, right? I have since learned that is not the case. And so a closing, to me, the difference between a closing and well, first off, let's talk about this. The real estate purchase contract doesn't use the word closing. It uses the word, what is it? Settlement. And so settlement means when the parties have all settled, means they've all signed, right? Now, but people will confuse that with closing with title, right? Like you're at the table, you're closing then and there. That doesn't necessarily mean settlement if both parties are not doing it at the same time. And also when you're explaining that term to your buyers or your sellers, what do you think they're thinking? They're thinking, oh, I get the keys today. So everybody thinks it's different, but yes, this is good to have that clarified.
You bet. So settlement is when we actually sit down and sign, but know that title folk call closing settlement. It's interchangeable in our language. So just know that when you're dealing with your title people so that you get on the same page. And closing means once it's been, from a realtor perspective, means once it's been funded and recorded. Title people will say closing when we're sitting down to sign, and funded and recorded is another term, and it just means then we are done. So
now you threw in funded and recorded, another one. So agents, just know when title says a term like closing, that's you're going in to sign, right? Funding and recording is what we think closing is, and settlement is when both parties have signed for the real estate side. Okay, thanks, Heather, for that clarification.
Absolutely. So a cloud on title, that's just any equitable interest that causes doubt of ownership or anything. So there could be a deed that wasn't done correctly. That could be a cloud on title, or it could be a lien or a notice of interest. That's what those are for. A conveyance, that's an actual document that transfers the title of the property over. A deed is the document used to convey title. So it's the actual document that does the conveying of the title.
Okay. All right.
Okay. So easements. Easements are a right to use somebody else's property or land. The most common easements would be public utility easements. In any subdivision, typically you're going to see a public utility easement. Often it's like 8 or 10 feet around the outside perimeter of your property. But there could be an easement from in a larger piece of land where somebody uses that to access it. Or if you're dealing with like a flag lot, for example, you may have an easement to use a driveway to get back to your piece of property.
Awesome.
An encumbrance is a claim or lien that affects its ownership. So it's just something that is found against the property, and we will need to clear that up. Escrow is an impartial third party that holds the money or documents until certain conditions are met. So we, as title companies, do escrow services for you. That's the process of collecting all of the funds and dispersing those funds. The estate, that is just how a person is held on the title. So there's various different versions of that. They could be tenants in common, they could be joint tenants, it could be literally the estate of somebody once they're deceased. Grantee and grantor.
This is the fun one. This is going to take you guys back to your real estate school days. Who's the grantor or grantee, and mortgagor, mortgagee. Okay, so I'm going to give you my way of remembering these two terms because it was difficult. And so I made the grantee is the one that receives, and the grantor is the one that transfers. Now that's not how you spell transfer, but that's how I remembered it. So just remember, if it's got the E to it, it's a receive. It's got the R, transfer. So transfer, grantor, mortgagor, right?
You know, I love that. I would even say, like, I love the receiver or receive for grantee. What about even gift or grant or,
Gift.
like, because you receive a gift, but the person giving it to you is the giftor.
I like that.
Anyway. All right. Good. A lien is any legal claim to a property or against a property that has to be satisfied before we are able to close.
Right.
Okay, next term. This is one that is specific to Utah. Preliminary title report. What else do we call that, Josh?
The commitment.
Okay.
The PR.
The PR. Yeah.
Yes.
So you'll hear people say, hey, you need to order a PR. Just so that you know that is the commitment for title insurance. So that's the document that we send to you that has the report of what's going on with this piece of property. It shows who's vested in title. It shows the items that are against it.
I have to tell you a fun story. When I first got into real estate, I didn't have a lot of direction and training. And so I was doing a deal for my sister, my very first deal, and negotiations were going great. I could do that part, but I didn't know everything I didn't know. And apparently you're supposed to get a preliminary report and a PR. And the other side said, hey, where's your PR? And I was like, my PR. And I'm like searching, what does PR mean? Well, PR means so many different things. And I'm just like, oh my gosh, what do I do? And I'm like, well, who gave you your PR? And then she gave it. And I was like, I reached out to that person, hey, can you give me a PR? I had no idea what it was until they provided it. So anyways, preliminary report or commitment. There you go.
Absolutely. Title insurance. So title insurance is the actual product that a title company is providing to you. It's the insurance that protects that lender or the buyer, showing that they are receiving property free and clear, or that their lien is in first position on the property. A title search is what we do in order to give you the information that is against a property and to know our roadmap for what we need to do to ensure that you're getting clear title.
Awesome. All right, now we got a bunch of those terms out of the way. Let's figure out, why do we need title insurance?
Okay, so title insurance protects against liens. Those liens are things that have been recorded in the past that either have been cleared up or things that haven't been cleared up. And depending on the coverage that you get, it may also include mechanics liens. And mechanics liens, you have taken title to the property.
Okay.
It protects you against fraudulent title transfers. So if somebody forged the name previously and sold a property, then that's when title insurance comes into play. You can make a claim on that title insurance policy.
Awesome. Okay. So if your clients are wondering why, that's exactly why, to protect them, make sure that they actually have the title to the property, hence title insurance. Okay. What is a split title, Heather?
Well, a split title is when the buyer and the buyer's agent work with one title company and the seller and their agent work with another title company. So split, we're splitting the act of the entire closing into two different parts.
Gotcha.
Now, there's good parts to that. There's bad parts to that. Some of the good things is obviously you're each representing both a side and working through that transaction. It kind of makes a fiduciary, typically a title company has a fiduciary responsibility to everybody involved, but yet we're only working with one side when we're doing a split title.
All right.
You can have really good confidence in working with an escrow officer that you worked with many, many times. And so that gives you a good feeling knowing that you know how the process is going to go. You know what the end product's going to look like, and you know what the experience is that your client will get. Now, some of the bad parts of it, it can delay things. Sometimes we have issues that pop up where one title company finds an item against a property and the other doesn't. And then we have to have some discourse and figure out who's right and who's wrong and how to fix that. And then the other part is that funds have to transfer to multiple places then. So the lender is going to send funds to the buyer's title company. And then the buyer's title company has to send funds to the seller's title company. And then the seller's title company records the warranty deed putting your buyer in title, and they have to then send that warranty deed back to the buyer's title company so that the loan document, the deed of trust, can be recorded against the property. So the transaction isn't complete until we've done all of that.
So you're creating an extra step, an extra middleman, per se.
Absolutely.
Okay. So ordering title, is it good to order title a few days before you're set to close?
No.
I will say I may have done that once.
It can happen. It can happen, and often we can accommodate that. But it's always best if you can order it as soon as possible. So if you're a listing agent, as soon as you know you're doing that listing, go ahead and order that title, because we can help you to know how to fill out your listing paperwork so that you have the correct people signing for the sale of the property.
Right. And so for you agents, for buyers, if you're working with a buyer, once you go under contract, then you will request that. For a listing, however, you want to make sure you have that stuff initiated early on. So that way, once you have it listed to the MLS, that you can then have that confidence that it's ready to go, and you're not, trying to rush things and you miss your seller's disclosure timeline. A lot of times people are giving 48 hours or something for a seller's disclosure, and then they don't have enough time to get it, or they forget and they lapse. So make sure you get that. As you're uploading your listing to MLS, you should have the PR, or what's it called again?
Title commitment.
Title commitment ready to go.
Okay. When you place that order, make sure that you tell your escrow officer a few things about it. So we're going to want contact information for your buyer or your seller. We need an email address, and we need their cell phone number. With the seller, we are definitely going to reach out to them because we need to get their payoff information. With the buyer, Typically, we don't reach out to them much before closing because your lender is working on most things. Now, if we're dealing with a cash transaction or something like that, we'll reach out directly to your buyer a little bit more often.
So if you got your client and I text you, here's John, and I just give you the number, are you going to know what to do with that?
No. So the other piece of this is we need the address of the property and we need the name of who you think is entitled, because sometimes that property address might not be correct or might not be what the county has. So we need those pieces of the puzzle to all connect together.
Full name, contact information, the property. And the thing I would add is agents do not just send them the contact and say, yeah, go ahead and reach out. Tell your clients someone's going to be reaching out and asking for information about them selling their home, so they don't feel like it's a scam and get all nervous about the whole situation. So
exactly.
So if you have an entity, what does that look like when you're buying or selling a home?
So when you have an entity, there's a few things involved there. One is we are going to need to see documents that prove who can sign for that entity. If it's a trust, we'll need a copy of the trust. It will give us who the trustees are and then how we can proceed and what powers they have. If it's an LLC, you're going to give us the articles of organization for that LLC. If it's a corporation, same idea. It's going to be articles of incorporation. But we need to have that information so that we know who can sign. We just need to be prepared, and we need to make sure that everything is legal and correct and not fraudulent.
Awesome. So now we're talking about power of attorney. So I had a fun example with this one. Is I had a veteran who was deployed, and he did not give power of attorney. But I had mentioned to the title company at that time, I won't disclose what title company that was, but I told him that he's getting deployed and his wife is going out of town. And so when they reached out to me and said, hey, we need to coordinate a closing and for them to come in and sign documents, I said, did you not coordinate with them like beforehand? And like, what do you mean? I'm like, remember that email I sent you saying that they're not going to be here in person? This is something that's super important that you communicate with the title company and make sure that you can trust them to, make sure that the communication is clean and crisp and all that, those pieces. But when you're talking about power of attorney, you can pass on the rights for somebody else to sign on your behalf. So another example, now years later, I'm wiser and prepared beforehand, is I told the veteran who's actually already deployed to talk to JAG and get permission for the power of attorney. And so he had it's actually his mother sign for the sale of their property. And so there's some things you can do, but what is the way that you would sign as a power of attorney? This is something people get wrong lots of times on contracts.
Okay, so a couple of things. Title company can prepare that power of attorney for you. You're going to want a limited or specific power of attorney that is very specific to that property you're dealing with. Somebody that is deployed often issues a durable power of attorney, which covers everything. And that can also be used in the case of a deployed individual, a military individual. When we're doing a power of attorney, it cannot be done for an entity, so that you know that, so you can't do that. But the person that's signing for you, so Josh, I'm going to use you and your wife, Christy. Okay. So Josh is out of town and Christy's going to sign for him. When she actually signs the documents, she's going to sign Josh Emfield by Christy Emfield, his attorney in fact. Every single time that there is a signature, that is how that signature will go. So make sure your power of attorney is a friendly person and happy to help you.
Now, what if they have like 5 names, 3 middle names? That's gonna be
that'll all be there.
Awesome. Okay. Deceased owners and conservatorship. I experienced this. I was working with a seller, and she had conservatorship because her mother did not have the mental capacity, right? So you can't have somebody sign a contract to sell their home if they don't have the mental state to make such decisions. They had already got the conservatorship beforehand, but in the process, she passed away. And so now they had to go through the court and get permission. And then but that can be a tricky thing. Same thing here, conservator for in behalf of so-and-so, and that's how they had to sign. But what are some of the things that you would suggest in these situations that agents do to prepare for this?
So that's part of why it's important to order, especially your listing up front, because in that process, we can figure out who is on title. Sometimes you find out that there's somebody that was deceased. You might be dealing with a spouse and their spouse is deceased and they haven't removed them from title yet. And depending on how they're vested, depends on if they have the right to do that of their own accord or if they have to go through probate.
Okay, so we're gonna go back to our real estate school days, and what's the types of ownership we're talking about here?
So there's tenants in common and joint tenancy. You are praying for joint tenancy in this scenario.
I think Heather's giving you guys PTSD from your studying days, but so yeah, you want to verify. And if you don't remember what it means, reach out to Heather or your specialized escrow officer and verify what does that mean and check in on that. But yes, so you want to make sure that they do have the right to sell the property, because if you sign with one person and you're listing, you're spending money on photos and everything else, and then it comes down to it and they can't sell the property, now you're out of money, time, effort, and frustrations and potential legal battles, with all that.
So Josh, we've done a transaction that was kind of crazy, right? We had a lot we're selling, and
oh yes, I was gonna say, which crazy one? We do lots.
Yeah. We pull the title and find we are thinking there are 2 people on title, and there's 4. Now they all have the same last name, and I said, "Do we know who these people are?" Yes, they were their children, and they were not 18, and that meant that they could not sign to convey the title.
Yes, and we had to go through a court order to give permission for the parents to then have the rights to make a decision for their children, and why they had to make this decision, because they were in a different state. Yeah, very, 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 confusing, and it delayed the process. But because you looked those items up, we were able to address that earlier on, and be able to sell that property.
Yeah, that was a good one.
Yeah. All right, so now we're going to talk about earnest money. So I'm going to jump in here first. So agents, do you remember the timeline for delivery of earnest money? I'll give you a hint. It's down here on the slide. It's on your Rep C. It's 4 calendar days. So if you can see that right there, I'm going to go ahead and just mark this real quick. But you got 4 calendar days here after acceptance. So what you're looking at with that is how much, what does delivery mean? Does that mean deposit? No, it means I get the check. I have 4 days to deliver it upon acceptance. Okay, so now here's where a lot of people get confused. What if it's 6 p.m. today? 6 p.m. today. Do I count today or tomorrow? When does that initiate? So it doesn't matter. It's not the time. This starts the next day. Now, is it business or calendar days? It's calendar days. See right here, calendar days. So anything that starts in this contract, you're going to say that has to do with the funding, and anything will start the next day. So you have it accepted. So 4 calendar days upon acceptance. So I would start, today's the 17th, so it's the 18th, 19th, 20th, 30th. But we have to have it delivered by the 30th.
18th, 19th, 20th, 30th?
Did I say 30th?
You did.
Oh, thank you. Thank you.
That's
Okay.
a fun counting way.
Yeah, I'm great at counting. Okay, we're gonna do that again. Okay, see if I can count to 4. Oh, that's 18, 19, 20, 21. There we go. All right. Well, there we go. If you want to get good advice and have Heather help you out, she'll keep you in check. So, but yeah, to the 21st. So you need to have it delivered by the 21st, which means you need to have it in hands and give it to your brokerage by that day. So 5 p.m. on that 4th day, give that to your brokerage before then. Don't show up at 4:59 and then they lock the doors, because then you don't have it delivered, right? Make sure you're getting that delivered. Now, the brokerage has 4 days to deposit those same funds. And so that's one thing to keep in mind. Now, you can have title do this, and you can do it. But if you're holding money at title, you need to use the title addendum. And I'll pull this up here in just one second. Let me share.
While you're pulling that up, Josh, I would sure love to remind people to pay attention to when there are federal holidays too, because your office may be closed. So if you've got, Martin Luther King Day or President's Day or one of those involved, then if you've gotten it accepted on a Friday, you really only have Tuesday to deliver those funds.
Yep. So try to avoid going under contract on late Friday and then having a holiday. So just keep in mind, you're absolutely right, Heather. So here's your form if you want to hold it with a title company. So in this case, I'm going to put the title company as secure title, located at, I put your address, and then I'd put your phone number, and then Heather Jackson or Heather at secure title, and then the information here. So this will be part of the agreement. Both parties have to agree to this. So what happens if you then submit to title company your earnest money? If you do that and now it's day 5 and you're like, oh, I'm sorry, we sent it to the title company, can you guys go ahead and sign this addendum allowing it? If they sign it, you're great. If they don't agree to that, you are in breach, and the earnest money is potentially going to be lost. And so you need to make sure that you're following up the information early on, ensuring that you're not going to have any hiccups there. So now you guys use a special program, and we also offer that at Realty Path, which is Earnest app, right?
Yes.
So explain a little bit what that does and why that's a benefit to the agents.
So earnest, you can deliver your earnest money in a few different ways. So one, the old-fashioned way was they would write a check, you would collect the check, deliver it to your brokerage or to the title company. Nowadays, you're not meeting with your clients to sign the contract. Typically, it's done electronically. So we've come up with solutions for that. So funds could be wired, or they can go through the Earnest app, which is an ACH way of doing it. That way, your people don't even have to go to the bank or anything. They can do it right from their phone.
And it's nice because the agent can request it and say, hey, guys, I just sent the request to you, so they know it's secure and it's easy. That's great. The one thing, guys, you need to pay attention to on the contract. So if you're looking down here, you can actually see agrees to deliver in 4 calendar days, but it'll say in the form of what? So if you don't put check, then you can't do a check. If you don't put wire, you can't do a wire. What I like to do is I will put check or wire, whatever you're looking at, just keep it a few options open. You can put check, wire, or ACH. Then that way there's no contesting the type of delivery. Now, will someone be petty and go after that? Probably not, but don't put yourself and your clients in that situation. So, yep, we already talked about those days. So delivery. Who orders the PR, Heather?
You, the agent, orders the PR. And it's important, especially on that listing side, because you have a responsibility with some sellers' disclosures issues.
Exactly. So when you put your seller's disclosure deadline in section 24A, it's referencing section 7. Everything here, and that's a lot of items here, everything here, it needs to be delivered by that deadline. A lot of people have a short, span deadline. Maybe it's 24 hours, a couple days, a few days. It may not be enough if you haven't done the due diligence early on to order the specific documentation. So we'll go through real quick some of these things. So the seller's property condition disclosure, usually agents do not miss that one. Lead-based paint, if it was a home built prior to 1978. A commitment for title insurance, also referred to as the PR.
PR.
Right? A copy of any restrictions, restrictive covenants, or CC&Rs. And then you have most recent minutes, budgets, financial statements, and homeowners association. This is one that people miss a lot. And for your bigger companies, usually they'll have a website you can go and pull down the documents. But when you have, we'll say Jack, who's running the HOA, it's a small HOA, and he doesn't meet very often and doesn't answer the phone call or look at an email regarding this, you may not get the documents in a timely manner. It may be pulling teeth to get that information. And so it's so crucial to have this beforehand. It also plays into, agents, your ability to market and prepare beforehand any potential issues. Maybe there is a fee that's been assessed from the HOA, and you need to be able to disclose that. And maybe there's other rental restrictions or agreements that say, hey, this is a great rental, but then you find out, oh wait, no, it's not allowed in this area. You've got to be able to look at some of those details. So a copy of long-term rental agreement, that's another one that gets missed frequently. Short-term rental agreements, existing property management agreements, water rights, notice to claims or conditions of seller related to environment problems in general. And then we are dealing with FERPTA. Is the seller a foreign entity, a foreign resident? So then if that foreign person is selling it, then they have to pay taxes, right? And what happens, Heather, if you're selling to a foreign, or a foreigner selling and you're buying it and they don't pay their taxes?
Then I'm, as the buyer, responsible for paying those taxes.
That's scary. So these are things you want to know early on, so that way if, like, for instance, we had one where someone was a foreigner, but they also had dual citizenship. So then we were fine, but we were going to hold money at title to protect that specific client. So these things do arise. Make sure that you do disclose all of these items before your deadline. So,
and Josh, whose responsibility is it to provide those things?
Great point. So your escrow officer, if you got a great one, and Heather will provide documents to me very quickly, and she's willing to send to people. But here's the thing: the seller is responsible for delivery, not another entity. So if they can find the documents on their own, but if you don't deliver them to them, you have not provided them with those documents. So it should be from you, the agent, not from the title company. Or if the title company does send it, make sure that they copy you, and then you reply back saying, hey, we've delivered these documents to you. Just making sure that you are engaged in it, ensuring that they delivered that from you as well. So,
and just a quick note on that. So the title company will provide you that title commitment. They will provide you any recorded CC&Rs, because those are recorded documents. We can pull them for free, and we're happy to share those with you. Sometimes it's tricky trying to email them to you, so we'll link them or do other things to get them to you, because they're just very large documents. But when it comes to those minutes and other documents that are from the HOA, we can obtain those, but typically we have to pay a fee to obtain those, and that fee would be passed along to your seller.
Right. Yeah. And a lot of the HOAs won't even give those documents to you, the agent. You require your client. So tell your client, say, you need to get these documents, make the list, make it super simple for them, and say, you need to order these documents right away because your earnest money is on the line. Tell them you could lose earnest money if you don't deliver this in time. you need to scare them a little bit because it is a scary thing for them to lose large amounts of earnest money. So that takes us to the PR. What does it look like? And we'll do a walkthrough. So Heather, I'll open this up, and if you can just give us a
Sure.
breakdown.
So the first few pages are the actual insurance policy jacket, and they just talk about the items that are located within that commitment and what the policy parameters are.
Okay.
All right. Now we get to the meat of it. This is the
All
stuff
right.
that's important that you look at. So this is the Schedule A. It's going to show you the property address of the property. It's going to show you who is the proposed insured. That means who is buying the property. It would show you a lender's name, and it will show you who is vested in title. So that's what entity or individuals own the property. So that's the first page. We could go on to the second page. The second page is the requirements section. I like to call this the roadmap for my job. So it tells me the things that I need to clear up in order to issue a title insurance policy. Some of those things are obtaining the actual policy premium from the individuals. We handle that at closing. It's on the settlement statement and collected through that process. And then it also talks about taxes and other liens that we need to take care of, mortgages, etc.
All right.
Now, the exceptions page, typically the first 8 items are what we call standard exceptions, and those just go over the standard items. When you issue a homeowner's insurance policy, which is the policy that is referred to in your purchase contract as the preferred policy to be issued, then those first 8 exceptions go away in the final policy. So then we start with the taxes. It shows if the taxes have been paid or they're delinquent. It shows the amount from the last year, or the amount that is owed if we make it to October, and we're doing this October, November time. Then there's some standard exceptions. They talk about mineral rights, easements, and then terms of plat that have been filed, unrecorded easements. And then we get down to the items that we've got to clear up. So deeds of trust are loans against the property. So in this case, we have a first loan, a second loan, and then there's a tax lien. So tax liens and judgments can also come up, and those items will have to be cleared up. Often when we get a tax lien or a judgment, we may ask you for more information about the individual that's against, because it may not be our person.
Right.
Like if we get John Smith as your seller, that's a pretty popular name.
It is.
And we may ask you for some more information so we can determine if that's our guy or not.
Right. And I actually had a client face that once, and they had a bunch of debts. It wasn't actually him, but he had a commenting as well. So now that takes us to the seller PR. And is that pretty much the same thing? Are we looking at?
It's pretty much the same thing. If it's the listing PR, then we won't have the proposed insured on it yet, because we don't know who that will be.
So this is important, guys. So when you ask your EO, so I'll ask Heather, your escrow officer EO, hey Heather, hey, I've got this listing. Can you get me a PR, or what is it called again?
Commitment.
Thank you. So if you get that PR or commitment, then you have it for the listing. However, like Heather said, once you have a buyer, you need a different one, an updated one. So when you're uploading these documents into like SkySlope, you do need the secondary one, the one that shows all the information with both parties. So
that first one we give you, that listing one, is sufficient for what you need for your seller disclosures, and you can give that. But as soon as you're under contract, you want to get that contract to us so that we can look and see if there's any judgments or issues against that buyer as well. And we will update that commitment and send a new one back to you. And that's the one you're going to put into your file for compliance.
Very good. Thank you. All right, so delivery of CC&Rs and HOA docs. So again, we touched on this a little bit already, but who's responsible for it? The seller, which means you as the listing agent, is responsible to make sure they're staying on top of the deadlines. And so you need to make sure, as in section 24A, whatever that date is, you have everything delivered to them before this date. One thing I would suggest to you guys is to always email them and then ask for them to respond and say, here's everything you received. Please confirm receipt of all needed documents for the seller's disclosure. Now they say, yes, we received everything. That's going to be extra protection for you. If they come back, oh, well, where's this document? Well, you said you received everything. Well, here's another piece. So just a little bit of extra protection there. So Heather, is it the escrow officer's job to get the HOA docs?
No.
And it's going to cost the client more, right?
Right.
Okay.
We will order, please understand, we will order an HOA payoff, but we don't order that until you're under contract.
Right.
And once you're under contract, we'll go ahead and order that. It also depends on when you're closing or settling. So if the settlement, let's just say that the settlement deadline is 2 months from the time that you get the contract to me, I'm not going to order it right away.
Right.
You know why I'm not going to order it right away? It's because I don't want your person to have to pay for it twice.
Right.
Okay.
And that's the same thing too, guys. If you don't need it way in advance. This is going to be 6 months, because what are they going to actually sell? Maybe they won't. Maybe they change their mind too. So it needs to be pretty close and solid before you start going down that path.
You bet.
Okay. All right. Seller's payoff. Since you started that discussion, we can continue on there.
Oh, good. So part of what I have to do is I'm the detective, and I get to figure out what things have to be paid off and how to obtain that information. So I will be reaching out to your seller and requesting some very private personal information from them. Please let them know that I will be reaching out, or your escrow professional will be reaching out, and who that is.
Social security numbers makes them a little bit nervous. So prepare your clients, saying, hey, they are going to need your personal information, social security, to be able to pull your data for the mortgage. Yeah.
Yes, absolutely. And often I will try to loop in my agent into that conversation, because I'll send a document for them to sign. We'll be requesting their loan numbers, their HOA people, their dates of birth, their social security numbers, all really private information. The other piece of that puzzle is that we require an actual signature. It can't be digitally signed. And it's not because we just don't like it. It's because the banks, especially the local credit unions and local banks, won't accept a digital signature. They need an actual physical signature. Now, I don't need that original paper back. I can take a picture or a scan of that paper without any issue, but I do have to have an actual signature on it.
That's great. So touching base on that too, I do this with all the EOs I've worked with, and you can attest to this too, is I initiate the conversation with the clients and title, so that way they know, okay, this is who we're talking to, and then that way they can reach back out. And I've had clients come to me multiple times and say, hey, they're asking for this. Is this okay? So, you want to introduce that and make sure that they feel open to those discussions with you. So,
Absolutely.
All right. Talking about judgments, knowing what those are. Here's our favorite judge of all time.
Love Judge Judy, right? Yeah. All right.
How far back can we go?
Okay, we can go back on judgments 8 years. So they fall off after 8 years, as long as they haven't been specifically recorded against the property. So judgments are recorded against people or entities. Okay, but not against property.
So let's start with me, for example. I rack up credit card debt, have a huge payment. I don't pay it. I refuse to pay it. Now that is and then they sue, they go to the court. I owe, let's say, $25,000 in credit card debt. Okay. That's a judgment against me.
Yes.
Okay. So now what?
So now when they get that judgment, it goes on to the court records so that I see that there's a judgment against you. And when we do a title search, we're checking the names of the individuals on title and the individuals that will be going on title for these judgments. So if we see any, we're going to bring them up and then we have to deal with them. If they haven't been what we call perfected in 8 years, they go away.
So let's just say I have that 25K debt, 7 years, 364 days later, I purchase a home. What happens?
Then we're going to say that those items need to be cleaned or cleared up. Most likely your lender will require it because it's going to show up on your credit.
If 8 years and 1 day,
you're good to go.
All right. Not encouraging people to rack up their credit card debt and wait 8 years, but just so you guys are aware what could really prevent your clients, these are some of those items. So
right. And often we have some judgments that show up on a regular basis. Those are divorce. That's a judgment because it's a court action. ORS, Office of Recovery Services, typically that would be for child support that hasn't been paid. And once you are on the ORS filing, then that will stay with you for the length of time that you have a child that's under the age of 18. And so we just have to verify that there isn't a balance owed at that time.
Okay, perfect. And some common, liens, we're talking about construction liens, tax liens, a mortgage, your second mortgage, those all have to be paid in order to satisfy the loan.
A HELOC, make sure your people understand that a HELOC is against the property and has to be closed. If you don't know what a HELOC is, it's a home equity line of credit.
Yes, they don't get to keep that. It's a credit card on the property. It does have a lien. Very good. Okay. All right. So now, beforehand, the MLS had the commission breakdown, whether it was net or gross, but now the forms have changed. But you still can negotiate it depending on how you utilize that. If you're using the real estate purchase contract, it's gross. Across the board, it's gross unless you specify otherwise in the addenda. So, however, in the brokerage compensation payment form, that one, if you're using that instead, you can specify whether it's net or gross as well. So, but your EO or your escrow officer is not going to know that unless you tell them or provide them the document. If it's in the rep sheet, okay, then you're good. But if it's outside of that, you've got to provide it or tell them what it is. And so, because that will change these numbers, as you can see, 14,700 based off of net and 15,000 based off of gross. So you want the title companies to be able to reconcile their forms and not run into that issue last second because it can delay the closing in a timely manner.
And obviously, we want to collect the right amount to get you paid. Remember that I love the new RepC, and I love the fact that the commission is just on there. And so it makes my job much easier than it used to be. However, if I am dealing with the listing agent, I don't know your commission unless you tell me.
Yep, absolutely. Okay. All right. So this is always fun. Now it might be getting more accepted, but the word addenda versus addendum. So actually, addendum is the singular word. Addenda is plural. So if you're around me and I catch you saying addendums, I'm going to give you a hard time. But yeah, if you're not providing all the addenda consistently to the title, what does that cause for you? What problems does that create?
Well, often I've seen I'll get a CD over from the lender. I'm balancing the CD, and there's a credit for seller paid closing costs, and that's in addendum 5, and I only have up to addendum 3. So I'm asking, do we have seller paid closing costs? And what is that amount? So that's one of the things. Obviously, your sales price could change, and then I've prepared documents that show a different sales price. So it's really important that we see all of the addenda.
This is super important that you copy in all parties. Whenever you send out a new addendum that is going out, it needs to go to all the respective parties. So the lending institution, also to your escrow, and to the other side. Make sure all the realtor on the other side, the escrow, and the lender. Otherwise, they're not going to be talking and there's going to be delays, because then things may have to go back through underwriting. Maybe you get it, Heather, but then they didn't send it to the lender. And it's like, hey, we're not matching here. Now you got a delay because the underwriter needs to look at it again. And you're up against a deadline and people already got movers. So it can be really problematic. So,
and be careful on when you're putting together your contract with those seller paid closing costs. Make sure that you're in good communication with your lender so that you don't leave money on the table.
yes, thanks for bringing that up. So everything you have, you can find a use for that money. I was being told by multiple lenders that you can't use it for some certain reason, that you can use the money. There are certain terms and items that are allowed even past certain restrictions. For example, like with the VA, there's a 4% maximum concessions. However, like a concession would be a temporary rate reductions, like a 2-1 buy down. It can be closing costs, but after that 4%, maybe you negotiated 5%. The permanent rate reduction can go above that. And so you always can utilize the money on hand. If someone's telling you can't utilize it, then you're not working with the knowledgeable LO that you should be. So
yeah, we can also often, if it's being left there, we could prepay some homeowners association dues, or we can do a 2-year home warranty instead of just a 1-year home warranty. There are many things that can happen. So make sure that you have super knowledgeable people you're working with. Your escrow officer and your lender need to work well together.
yes, a great point. Okay. Scheduling your closing. We already talked about this out of state situation. You can do mobile notaries, right? But is that going to cost more?
Absolutely.
It will, depending on where they're located, right? And so early on, don't wait till the last second and say, oh, I didn't tell you that they're out of town. Oh my gosh, we got to figure something out. It creates a headache, especially if they're like on a cruise. And so we want to be very careful to be preparing your escrow officer for everything that's happening in the transaction. They should be kept in the know early on. One of the best things I like to do early on is saying, hey, here's a tentative closing. And so that way, well, they're not going to be out of town. Hey guys, here's tentative. As long as everything goes accordingly, here's what we're looking at. As you get closer, hey, let's reaffirm this time or let's change it. Then that way everyone's kept in the loop. And yeah, you want to make sure that people aren't out of the country. It gets more complicated, right, Heather? If they're out of the country, what does that look like?
Well, now we can use a remote online notary if they have good internet service and the parameters required for their computer. Before, it used to be if they were out of the country and we didn't know ahead of time, they have to go to a notary. And some countries have notaries that are allowed by the US, but others do not. And then you have to go to the consulate, and that consulate could be 3 hours away. Oh, and by the way, it takes 3 weeks to get an appointment with the consulate.
That reminds me. So going back to that same one where the husband was deployed and the wife went to Brazil, I had to reach out to the consulate. Luckily, I had some contacts from time in working in Congress, and I spoke the language down there, so that helped too. But it creates a huge headache if you don't plan ahead and knowing. And so let your clients know, hey, you do need to be here in person, or we need to make some other arrangements. If you're planning to travel, let us know so we can justify those changes to make that.
Yeah, if you know they're going to be traveling, then let's get a power of attorney set up so that we don't have to have those issues, or make sure that the parameters will be met with that remote online notary. So a remote online notary and a mobile notary, typically they're about $150. So that's an additional cost. And we need to know that early if the lender will need to be aware of that as well.
Right. And so, yeah, keep everything those schedules clear to statement. So settlement statement, the thing I've learned over all these years is that when you show up to the closing and you haven't prepared your clients beforehand, they're nervous. They're scared about money transfers. They're thinking there's fraud going on. They don't understand these forms, what they look like. Do not wait till the closing. Remember, your guys' closing, our settlement, to go and review that documentation with them. So what I do, and Heather will provide this to me when I have a closing with her, and I'll say, okay, yeah, what's the statement? And then I can look at these, verify on my end first if I see any issues. If everything looks good to me, then I can just pull this open and then walk through it with my clients and explain to them what it means. So here I can go and say, yep, hey, here's the total purchase price. Here's your existing loans. Here's your reimbursement for repairs. Counting your taxes, you go down, here's your commissions and other little fees. And then here's your take home. You're expecting 48,000? Oh, we were expecting 51. What does that mean? Well, let's go back through. Here's all your dues for HOA. Oh yeah, I didn't know about the HOA dues. Well, that's why there's a little bit difference in that price. Walk him through it now, so when they get to the closing table, it's all, puppy dogs and picnics at that point. You want it to be a very happy experience, nothing stressful, because this is your opportunity to shine, for them to be with you, for you to take pictures, give a gift to them, so they remember you for future reference. So anything else, Heather, on this end? Yeah.
I just think it's important that you review that settlement statement. There are things like who's paying the home warranty, who is paying for the HOA transfer fees or the reinvestment fees, which can be quite large. So making sure that all of those things, those details are correct. And then, yes, go over it with your client. And then they are happy when they walk into the closing.
Yep. And this is a great opportunity for you to verify, hey, did I get all addenda over to Heather, for example? And, oh, wait, did the commissions change, or the price change, or, repairs costs, or, any of that stuff. Keep that up top of mind.
So with a seller, it's very easy to get that to you ahead of time. With the buyer side, we get it to you as quickly as possible, but obviously we have to wait until the lender provides us their closing disclosure so that we can create the settlement statement with all of their fees involved. Right.
Perfect. Okay, so closing disclosure, that's the CD, guys. This is the one that you're not necessarily privy to. The lender isn't supposed to give this to you. Now, sometimes they do, but they have to have the buyer give this to you. So it's privacy, rules that dictate who can provide that. So you have to get permission, or they need to provide it directly to you. So it is helpful for you to actually take a look at this beforehand as well. Just make sure your buyer understands. A lot of times the LOs will not review this with the buyer. And so then they're like, I don't know what any of this means. This is going to be prior to doing the settlement statement, but anything else you have to add to this?
So when I sit down in a closing, I do it differently with a buyer than with a seller. So with the seller, we go over that settlement statement we just showed you, just because it's super easy. Credits are on one side, debits are on the other side. It just makes sense, right? And then the closing disclosure has all those same numbers. They just organize them differently. With a buyer, the closing disclosure is a much longer document. It's a 5 or 6 page document. And if you can get through page 1 with them, it shows them the sales price. It shows their loan amount. It shows their interest rate. It shows the payment amount that they're going to be making and the cash that they need to bring to close. So we get through that first page first, and everybody's happy. They understood it. Then the rest of the closing is going to go great.
Right. And if it's a cash, buyer, then
no CD.
Yeah, no CD. They can just get the 24-hour prior to settlement. They just need to have time frame to get everything completed. But if you're getting a loan, you do need 3 calendar days prior to settlement. Now, funny thing is some lenders will add an extra day in here because they don't count like Sunday or, so I've heard different stories. So
It's interesting when we were talking about the dates for like your earnest money, and we begin those the day after, right? The day of the acceptance is not the date that we start counting,
right.
it's the day after. And I find that the lenders, some of them count the day they received,
Yeah.
and some of them count from the next day, 3 days. And it's different with different lenders. So just be prepared for that and ask so that you know what's happening.
So you're
And
not
some of these lenders will send out like kind of a preliminary CD well in advance so that they don't have to worry about that.
Yes. Very good. All right. So closing table expectations, again, do your settlement statement beforehand so they're happy. Inform them to bring, how many IDs do they need?
2 forms of ID when they're a buyer.
And one of them has to be what?
A government issued ID that is acceptable for a notary to be able to notarize the documents.
Right.
It needs to have a picture, a physical description of the individual, and a signature.
And it can't be expired. My sister, when she bought one of her homes, she showed up and it's literally the day before her license expired. She's like, well, here, it's expired, but here, I'm good. And she's like, well, we can't actually close with that. So we had to wait. She had no other ID. We had to wait to actually get an official state ID. But make sure that they have their IDs ready to go hand. And give them a time frame, what to expect time frame, and say, hey, we're gonna go have a good time. This is a great time to take pictures, to get reviews for you, and give a housewarming gift, any of that stuff. And then you also want to be prepared to tell your clients about expectations on possession and review that, and then review that also with the other side. Sometimes they forget what was checked, what was negotiated. So just reconfirm, hey, we are coming this time frame. It's better to do that now than show up with a moving truck and they're still in the home, and now you got a big fight and upset people. So, and then utility step as well, knowing who they should be in contact with so they don't just show up and then don't have power and gas, and that would be a huge headache. Anything else you would add to closing table expectations?
Your closing table should just be, it should be a celebration. It should be exciting that they're accomplishing this goal of theirs to either buy or sell. So it should be fun, and you should kind of let them know about how long to expect to be there. With a buyer, I typically say about an hour, and with a seller, 30 minutes.
Okay, perfect. All right, so when you bring cash to close, can you use cash for anything? Actual cash?
No, you can't. One is, we as title companies, we don't accept cash. We don't keep cash on hand. We're not a bank. That's just not what we are set up to do.
And that's good. So cashier's checks work,
Cashier's check works if it's under $10,000.
Good point. If it's above, then you just need the wire, right?
Correct. And if we're trying to fund the same day, a cashier's check needs to be deposited before we can fund. So don't bring a cashier's check if you're expecting to fund that day. If you're good to fund the next day, great, bring the cashier's check.
So best option in most cases is the wire, and getting that before 3 p.m., which is the cutoff Mountain Standard Time. So agents, it's your fiduciary responsibility to look out for your client's best interest to include wire fraud. You need to make sure that they sign their wire fraud disclosure, and explain to them, don't send money to anybody. If anyone's asking to send money, double check, verify. You should be engaged in helping protect them. There's been so many cases where money gets, stolen and the FBI gets involved, but it's very difficult for them to recollect, especially if it's out of the country. And there's so minimal amount of agents to work in that. They may lose all their savings. They may lose all their equity. Don't let that happen. So, all right, sellers proceeds. Tell us anything you would say in this process. What should they expect on how to receive those funds?
So I recommend that we wire most of the time. We don't charge a fee for that. But they will need to bring the information for us to be able to wire. So they'll need the name of the bank, the routing number, the account number, and whose names are on the account. The other thing to be aware of is if you're dealing with like a trust or an entity, that money needs to go to that entity's account that's been set up.
Very good. Yeah, and I had this experience too. Like I had a father wanting to send the funds to his account, but the property was in the daughter's name, but she wanted him to handle everything. So it can't happen that way. It's got to go to that person, and that she is okay in approving that to go somewhere else. So, all right. So that takes us over to delivery of commission. So do you give the commission to the agents?
No.
Okay. Agents, if you are having the title company give you the commission, it's wrong. Unless your brokerage allows it, the title company cannot provide that. The state is kind of gray on this area. They're saying, well, you kind of can, but the brokerage has to do their accounting appropriately, otherwise they can get in trouble. So unless your brokerage is saying okay, and unless they're doing accounting appropriately, it does not get paid out from the title company.
So I would have to have instructions from that brokerage that specifically says, send X number of dollars to the brokerage, send X number of dollars directly to that agent.
Yeah, just avoid this at all costs, commissions, and receiving any benefit from this. You need to run that through your brokerage. Any money coming in for real estate purposes has to go through the brokerage unless otherwise approved. Okay, so who chooses the home warranty? If you guys remember on the Rep C, it's going to dictate who chooses it, who orders it, who pays for it, and how much. So this is an important aspect. Do your clients know which company they want? Have you given them a few options? You should give them a few options to choose from. If they don't care, then you can just, and you can do this, or if you work with a great EO, like I'll have Heather order this for me, which is a time saver for me. They're already in that process. So anything else you would say about home warranties, Heather?
We're happy to help. Again, we need to have that email address, the phone number of the client in order to order those home warranties, because the home warranty will reach out to them with the information.
Right. And I would advise your clients to say, hey, if you have a home warranty question, reach back out to me and I can give you some guidance, because sometimes they may say something that may negate their ability to get the property. Now, we don't want them lying, but they might say, well, it might have been here before, so I don't know if it's covered. If you say something like that, they're going to always say, well, it sounds like it's pre-existing. So unless they know, they don't know. So there's some things you want to take care of. Okay, utilities. Who's responsible for setting up the utilities?
Well, that's your actual buyer.
That's the actual buyer. They have to go in and manually set up, but they need what to usually get that set up?
They probably need to know who to contact, who provides those items in their area. So if you're in an area, I'll use Lehigh as an example, they own their own power company. So when you call them to set things up, you're going to get water, sewer, gas, or not gas, sorry, water, sewer, electric. And then you'll just have to call the gas company, which now the name of the gas company is Enbridge.
Yeah, they keep changing. So frustrating. So yes, what about for HOA? Like, how does that get set up?
Those HOAs, they're always fun. So depends on the HOA. Sometimes they send a setup document in the midst of the documents that they send with the payoff statement. So we can fill those out in the closing and then send that in. Otherwise, they're just kind of guessing. So it's good to reach out directly to the HOA.
What I would suggest to our agents is that you will send an email or have a prepaid or a pre-made template that will specify who's gas, who's electric, who's the city, and then some internet providers in the area, and then contact for the HOA. So that way they're not like searching and getting confused. At bare minimum, tell them the contact for the city, and they can call the city, and the city can then give them direction as to what utilities are included and not included with the city. But so now when you get to funding and recording, this is another big item, is possession. Now in section 3.3, it gives you a few options upon recording, which is when, Heather?
Well, upon recording is whenever I call you and tell you it's recorded.
Okay, when we know it's recorded, right? Okay,
Absolutely.
You get possession right then and there. After a certain amount of hours after recording, it can be 6, 10, 12, enough, whatever they need. You can also have calendar days after recording. I would not ever suggest to put hours after recording because you don't know exactly when that is. Upon recording, when both parties know it's done, is you're good to go. That means that they just know, hey, they need to be out beforehand. Usually that's okay. But calendar days after recording is usually the better option. But I always will suggest people to do an addendum and specify exactly when they plan to possess the property. Then there's no question like, well, when are we counting? Are we counting the next day? We talked about all these different dates, right, Heather?
Right.
And do we count today? Do we count tomorrow? And I've had this happen with some agents like, well, I thought that meant the next day. I'm like, no, it doesn't. It doesn't. It counts, the day of. And so what does that look like? Just specify that in an addendum, and then you will be in a good position. Now,
on the hourly one, just so that you understand. So remember, I talked about how we deliver funds, and then the one side records, and then the other side records. So when you have a buyer, I'm calling you after we've recorded on that loan against the property. The property could have been in their name for over an hour before I call you, depending on which county we're dealing with. So when you're dealing with hours, then is it the time that the warranty deed was recorded? Is it the time the deed of trust was recorded? Is it when they called me? It's so confusing. So that's why Josh says, don't do hours, because it's more confusing.
Yes, exactly. Thanks for that clarification. All right, so that takes us through from contract to close. So we verified a lot of different things. And if someone's new to the industry, Heather, and they have questions, are you like, is it okay for them to reach out? How do you feel? Because like my first deal, I was scared to death and I didn't know what a PR was. Are you going to be like peeved if someone reached out to you like, hey, can you guide me and tell me what to do here? How does that work?
No, I love to educate people. So if you've got any questions, I'm happy to sit down. I'll go over a title commitment with you. I'll go over settlement statements with you, teach you the spots to look for and things to be prepared for when you're looking at those and reviewing those. So yeah, reach out. I am happy to help.
All right. Okay. Well, that concludes our class for today. Again, this is going over from contract to close, knowing title and escrow. And thanks for joining us today, Heather, and giving your valued feedback. So
thanks, Josh.